Doctrine of continuity of jurisdiction, adherence of jurisdiction. Under this rule, jurisdiction, once it attaches, cannot be ousted by the happening of subsequent events, although of such a character which should have prevented jurisdiction from attaching in the first instance. Ramos versus Central Bank of the Philippines. The court, once jurisdiction has been acquired, retains that jurisdiction until it finally disposes of the case. De La Rosa versus Roldan. As a consequence of this principle, jurisdiction is not affected by a new law placing a proceeding under the jurisdiction of another tribunal, except when otherwise provided in the statute, or if the statute is clearly intended to apply to actions pending even before its enactment. People versus Kawaling. Thus, when RA 7691 expanded the jurisdiction of the first-level courts, said courts acquired jurisdiction over cases that under BP 129 were originally within the jurisdiction of the RTC, but cases pending already with the RTC at the time of the effectivity of the law were not affected by such new law, unless the parties, by agreement, pursuant to Section 7 therein, agreed to transfer the pending cases from the RTC to the lower courts, especially those which have reached the pre-trial stage. In an action for ejectment, if the defendant voluntarily surrenders the premises subject of the action to the plaintiff, the surrender of the property does not divest the court of jurisdiction. Pamintuan versus Tiglao. If the court has jurisdiction to act on a motion at the time it was filed, that jurisdiction to resolve the motion continues until the matter is resolved and is not lost by the subsequent filing of a notice of appeal. Asmala versus Comelec. The trial court did not lose jurisdiction over the case involving a public official by the mere fact that said official ceased to be in office during the pendency of the case. Flores versus Sumaljag. Also, the jurisdiction that the court had at the time of the filing of the complaint is not lost by the mere fact that the respondent judge ceased to be in office during the pendency of the case. Victory Liner versus Belosilo. Even the finality of the judgment does not totally deprive the court of jurisdiction over the case. What the court loses is the power to amend, modify, or alter the judgment. Even after the judgment has become final, the court retains jurisdiction to enforce and execute it. Echagray versus Secretary of Justice. Exception to the rule of adherence or continuity of jurisdiction. 1. When there is an express provision in the statute on retroactivity application. Or 2. The statute is clearly intended to apply to actions pending before its enactment. Or number 3. The statute is curative. This means that even if originally there was no jurisdiction, the lack of jurisdiction may be cured by the issuance of the amendatory decree, which is in the nature of a curative statute, with retrospective application to a pending proceeding, and cures that lack of jurisdiction. Thus, in a case, while the CFI has no jurisdiction over a complaint for damages arising from the dismissal of a radio station manager, which was filed on August 2, 1976, PD 1367, vesting the court with jurisdiction over such type of cases, cured the lack of jurisdiction of the trial court at the time the instant claim was filed before it. Garcia versus Martinez. Read also at last Fertilizer versus Honorable Exaltation Navarro. How jurisdiction over the subject matter is acquired by the court. 1. It is conferred by law, applicable at the time of the commencement of the action. 2. Jurisdiction must be properly invoked by filing the complaint or information. Doctrine of primary jurisdiction. Statement of the doctrine. Under this doctrine, courts will not resolve a controversy involving a question which is within its jurisdiction and also of an administrative tribunal, especially where the question demands the exercise of sound administrative discretion requiring special knowledge and experience of said tribunal in determining technical and intricate matters of fact. Villaflor versus CA. Where a case is such that its determination requires the expertise, specialized skills, and knowledge of the proper administrative bodies because technical matters or intricate questions of fact are involved, then relief must be obtained in an administrative proceeding before a remedy will be supplied by the courts, even though the matter is within the proper jurisdiction of a court. This is the doctrine of primary jurisdiction. It applies where a claim is originally cognizable in the courts and comes into play whenever enforcement of the claim requires the resolution of issues which, under a regulatory scheme, have been placed within the special competence of an administrative body. In such a case, the judicial process is suspended pending referral of such issues to the administrative body for its view. U.S. versus Western Pacific Railroad Company. Example: damages is claimed rising from the collision between the claimant's vessel and that of another. Such claim can of course be determined by the courts, but in order to enforce such claim before the courts, there must be a determination of which vessel is at fault. This issue is placed within the special competence of the Maritime Industry Authority or Philippine Coast Guard, which administrative body regulates sea travel. Under this situation, courts should differ from the jurisdiction of such administrative body, for it has the competence to determine which vessel is at fault. Its finding then can serve as basis or premise for the legal consequences to be then defined by the court. In Far East Conference versus U.S., the court defined the primary jurisdiction doctrine as follows: a principle now firmly established that in cases raising issues of fact not within the conventional expertise of judges, or cases requiring the exercise of administrative discretion, agencies created by Congress for regulating the subject matter should not be passed over. This is even though the facts after they have been appraised by specialized competence serve as a premise for legal consequences to be judicially defined. Uniformity and consistency in the regulation of business entrusted to a particular agency are secured, and the limited functions of review by the judiciary are more rationally exercised by preliminary resort for ascertaining and interpreting the circumstances underlying legal issues to agencies that are better equipped than courts by specialization, by insight gained through experience, and by more flexible procedure. Since the inception of the doctrine, courts have resisted creating any fixed rules or formulas for its application. In every case, the question is whether the reasons for the existence of the doctrine are present and whether the purposes it serves will be aided by its application in the particular litigation. As the origin and evolution of the primary jurisdiction doctrine demonstrate, the reasons for the existence and the purposes it serves are twofold: the desire for the uniformity and the reliance on administrative expertise. Thus, in determining whether to apply the primary jurisdiction doctrine, we must examine whether doing so would serve either of these purposes. These same tests were applied by our courts in the determination of whether or not to apply the doctrine of primary jurisdiction. Espouses Jose Abejo and Aurora Abejo versus Honorable Rafael de la Cruz. CGMA Network versus ABS-CBN Broadcasting. In PART versus CA, the court said that enforcement of forestry laws, rules and regulations, and the protection, development, and management of forest lands fall within the primary and special responsibilities of the DNR. By the very nature of the functions, the DENR should be given a free hand, unperturbed by judicial intrusion, to determine a controversy which is well within its jurisdiction. The assumption, therefore, of the replevin suit by the trial court filed by the private respondents constitutes an unjustified encroachment into the domain of the administrative agency's prerogative. Quasi-judicial bodies like the CSC are better equipped in handling cases involving the employment status of employees of those in the civil service, since it is within the field of its expertise. Paloma versus Mora. Doctrine of ancillary jurisdiction. It involves the inherent or implied power of the court to determine issues incidental to the exercise of its primary jurisdiction. Under its ancillary jurisdiction, a court may determine all questions relative to the matters brought before it, regulate the manner in which a trial shall be conducted, determine the hours at which the witnesses and lawyers may be heard, direct and deposition of money deposited in court in the course of the proceedings, appoint a receiver, grant an injunction, attachment, or garnishment. Doctrine of judicial stability or non-interference. General rule: no court has the authority to interfere by injunction with the judgment of another court of coordinate jurisdiction, or to pass upon or scrutinize, and much less declare as unjust, a judgment of another court. Industrial Enterprise versus CA. Exemption: the doctrine of judicial stability does not apply where a third-party claimant is involved. Santos versus Bayhon. Objections to jurisdiction over the subject matter. The court may on its own initiative object to an erroneous jurisdiction and may ex miro motu take cognizance of lack of jurisdiction at any point in the case and has a clearly recognized right to determine its own jurisdiction. Fabian versus Desierto. When it appears from the pleadings or evidence on record that the court has no jurisdiction over the subject matter, the court shall dismiss the same. Section 1 of Rule 9, Rules of Court. The earliest opportunity of a party to raise the issue of jurisdiction is in a motion to dismiss filed before the filing or service of an answer. Lack of jurisdiction over the subject matter is a ground for a motion to dismiss. Section 1, letter B, Rule 16 of the Rules of Court. If no motion is filed, the defense of lack of jurisdiction may be raised as an affirmative defense in the answer. Section 6, Rule 16. Under the omnibus motion rule, a motion attacking a pleading, like a motion to dismiss, shall include all grounds then available, and all objections not so included shall be deemed waived. Section 8, Rule 15. The defense of lack of jurisdiction over the subject matter is, however, a defense not barred by the failure to invoke the same in a motion to dismiss already filed. Even if a motion to dismiss was filed and the issue of jurisdiction was not raised therein, a party may, when he files an answer, raise the lack of jurisdiction as an affirmative defense because his defense is not barred under the omnibus motion rule. Thus, the prevailing rule is that jurisdiction over the subject matter may be raised at any stage of the proceedings, even for the first time on appeal. Kalimlim versus Ramirez. The issue is so basic that it may be raised at any stage of the proceedings, even on appeal. In fact, courts may take cognizance of the issue even if not raised by the parties. There is thus no reason to preclude the Court of Appeals, for example, from ruling on this issue even if the same has not yet been resolved by the trial court below. Asia International Auctioneers versus GR number 163445. Lack of jurisdiction is one of those accepted grounds where the court may dismiss a claim or a case at any time when it appears from the pleadings or the evidence on record that any of those grounds exist, even if they were not raised in the answer or in a motion to dismiss. That the issue of lack of jurisdiction was raised only by the defendant in the memorandum filed before the trial court did not render them in estoppel. VDA de Barrera versus Ears of Vicente Legazpi. When the court dismisses the complaint for lack of jurisdiction over the subject matter, should it refer or forward the case to another court with the proper jurisdiction? It is submitted that the court should not do so. Its only authority is to dismiss the complaint and not to make any other order. Objections to jurisdiction and estoppel by laches. Estoppel means you cannot disown your act by which you have misled another, while laches means abandonment of a right for failure to assert it for a long time. General rule: you can raise your objection on jurisdiction over the subject matter even for the first time on appeal. The only exception is when there is estoppel by laches, as laid down in Tiham versus Sibong Hanoi. In this case, a complaint for collection cognizable by the inferior court was filed in the CFI. The jurisdiction was not questioned. The CFI issued a writ of preliminary attachment, but was dissolved when the defendant filed a counter bond to a surety. After trial, the court rendered a judgment against the defendants. That decision became final and a motion for execution was filed and granted. When implemented, the writ of execution was unsatisfied, so the plaintiff moved that the writ be executed against the counter bond. The surety filed an opposition and sought to be relieved from liability. The motion was denied on ground that the surety was not notified. Plaintiff then filed another motion, second motion for execution. Since the surety failed to oppose the motion was notifying the surety this time, the surety moved to quash the writ against the counter bond, but the motion was granted. The surety moved to quash the writ against the counter bond, but was denied. The surety went to the Court of Appeals, which affirmed the order. The surety filed a motion for extension of time to file a motion for reconsideration, which the CA granted. However, instead of filing a motion for reconsideration, the surety filed this time a motion to dismiss on ground that the CFI did not have jurisdiction over the subject matter. Instead of deciding, the CS certified the case to the Supreme Court because the issue raised is purely legal. The court emphatically declared, the facts of the case show that from the time the surety became a quasi-party on July 31, 1948, it could have raised the question of the lack of jurisdiction of the Court of First Instance of Cebu to take cognizance of the present action by reason of the sum of money involved, which according to the law then in force was within the original exclusive jurisdiction of inferior courts. It failed to do so. Instead, at several stages of the proceedings, in the Court Ako as well as in the CA, it invoked the jurisdiction of said courts to obtain affirmative reliefs and submitted its case for a final adjudication on the merits. It was only after an adverse decision was rendered by the CA that it finally woke up to raise the question of jurisdiction. Where to sanction such conduct on its part, we would in effect be declaring as useless all the proceedings had in the present case, since it was commenced on July 19, 1948, and compelled the judgment creditors to go up their Calvary once more. The iniquity and unfairness of this is not only patent, but revolting. In other words, while jurisdiction as a rule may be raised at any stage of the proceedings, Panganiban v. CA, a party may be stopped from raising such questions if he has actively taken part in the very proceedings which he questions, belatedly objecting to the court's jurisdiction in the event that the judgment or order subsequently rendered is adverse to him. Aldi versus FGU Insurance Corporation. In general sense, estoppel by laches is failure or neglect for an unreasonable and unexplained length of time to do what ought to have been done earlier. The failure to act warrants the presumption that one has abandoned his right, or that he had acquiesced to the correctness and fairness of what has been resolved. The doctrine of estoppel is based on public policy intended to discourage stale claims. Estoppel is not a question of time, unlike the statute of limitations. It is rather based on the iniquity or unfairness of permitting a claim to be asserted at a time such claim is presumed to have been abandoned. Spouses Guillermo Agbada and Maxima Agbada versus interurban developers. The fact pattern common among those cases wherein the court invoked estoppel to prevent a party from questioning jurisdiction is a party's active participation in all stages of a case, including invoking the authority of the court, in seeking affirmative relief, and questioning the court's jurisdiction only after receiving a ruling or decision adverse to his case for the purpose of annulling everything done in the trial in which he has actively participated. As clearly pointed out in Lau v. Republic, a party who has invoked the jurisdiction of the court over a particular matter to secure affirmative relief cannot be permitted to afterwards deny the same jurisdiction to escape liability. The Supreme Court frowns upon the undesirable practice of submitting one's case for decision, and then accepting the judgment only if favorable, but attacking it for lack of jurisdiction if it is not. Bank of the Philippine Island versus ALS Management and Development Corporation. Bar by estoppel is an exception and not the general rule. The doctrine laid down in Tiham is the exception to and not the general rule. Pangilinan versus CA. Estoppel by laches may be invoked to bar the issue of jurisdiction only in cases in which the factual milieu is analogous to that of Tiham. In Tiham, the defense of lack of jurisdiction was raised for the first time in a motion to dismiss filed by the surety almost 15 years after the questioned ruling had been rendered. At several stages of the proceedings, in the Court of Quo, or as well as in the Court of Appeals, the surety invoked the jurisdiction of the said courts to obtain affirmative relief, and submitted his case for final adjudication on the merits. It was only when the adverse decision was rendered by the Court of Appeals that it finally woke up to raise the question of jurisdiction. Regalado versus Go. In spite of Tiham and subsequent cases which invoked it, the rule that the lack of jurisdiction over the subject matter may be raised at any stage of the proceedings, even on appeal, still remains the prevailing rule, and Tiham should be confined only to situations prevailing in a particular case viewed in the light of the special circumstances surrounding it. Jurisdiction over the person, parties. Q. Define jurisdiction over the person. Jurisdiction over the person is the power to render a personal judgment against a party to an action or proceeding through the service of process or by voluntary appearance of a party during the progress of a cause. Banco Español Filipino versus Palanca. It is the power of the court to bring before it persons to be affected by the judgment so as to give him an opportunity to be heard and to render a judgment binding upon this person. In criminal cases, how does the court acquire jurisdiction over a person of the accused? By having him arrested, by service of the warrant of arrest, or by his voluntary surrender. Even if he is not arrested, can the court try an accused? Of course not, because the court has not acquired jurisdiction over his person. There must first be an arrest or surrender. The accused can post bail and be released, but if he jumps bail, there can be trial in absentia. There will be a valid decision because the court has already acquired jurisdiction. Of course, we cannot enforce the decision until we catch him. How does the court acquire jurisdiction over the person? In civil cases, it is also a must that the court acquires jurisdiction over the person of the parties. The manner by which the court acquires jurisdiction over the parties depends on whether the party is the plaintiff or the defendant. So, as to plaintiff, jurisdiction over the person of the plaintiff is acquired by his or her filing of the complaint or petition. By doing so, he submits himself or herself to the jurisdiction of the court. The vow Light and Power versus CA. Example: X, a resident of Melbourne, Australia, presented a complaint against Y, a resident of Manila, before the CFI of Manila for accounting and damages. X never came to the Philippines to file the suit and is only represented in this case by counsel. Y files a motion to dismiss the complaint on the ground that the court acquires no jurisdiction over the person of X. Should the complaint be dismissed on said ground? Why? No. It is a recognized procedural rule that jurisdiction over the plaintiff is acquired by his or her filing of the complaint in court. By filing the complaint through his or her counsel, X invoked the jurisdiction of the court over his person. Now, as to defendant, jurisdiction over the person of the defendant is required only in action in personam. Astia Vest, Limited versus CA. Jurisdiction over the person of the defendant is not a prerequisite in an action in rem and quasi in rem. Commerce versus CA. Jurisdiction over the person of the defendant in actions in personam, how acquired? Jurisdiction over the person of the defendant is obtained either by a valid service of summons upon him or by his or her voluntary submission to the court's authority. Angping versus CA. The service of summons is intended to give official notice to the defendant or respondent that an action has been commenced against him. He is thus put on guard as to the demands of the plaintiff as stated in the complaint. The service of summons is an important element in the operation of a court's jurisdiction upon a party to a suit because it is the means by which the court acquires jurisdiction over his person. Without service of summons, or when the service is improper, the trial and the judgment being in violation of due process are both null and void. Avon Insurance plc versus CA. The mode of acquisition of jurisdiction over the plaintiff and the defendant applies to both ordinary and special civil actions, like mandamus or unlawful detainer cases. The first instance when a court acquires jurisdiction over the person of the defendant is through a service upon him of the appropriate court process, which in civil law is called service of summons. This is the counterpart of warrant of arrest in criminal procedure. So if the defendant was never served with summons, any judgment rendered by the court will not bind him. Even if he is the loser in the case, judgment cannot be enforced because the court did not acquire jurisdiction over his person. The same principle holds true in criminal cases. A court cannot try and convict an accused over whose person the court never acquired jurisdiction. In criminal cases, the court acquires jurisdiction over the person through the issuance and service of a warrant of arrest. The warrant cannot have its effect even if it was issued if the same had not been served, example by effecting the arrest of the accused by virtue of a warrant. In criminal cases, how can the warrant of arrest be effected? Well, once an information has been filed in court, the court issues a warrant. Then the arresting officer will arrest the accused. The court acquires jurisdiction by enforcement of service for effective arrest of the accused pursuant to the warrant of arrest. The second instance is by his voluntary submission to the jurisdiction of the court. Another way to acquire jurisdiction over the person of the accused even if the accused is not arrested, is through voluntary surrender. Since there is no more need for the warrant, the court will recall the same. In civil cases, it is the voluntary submission of the defendant to the jurisdiction of the court. Defendant was served with summons improperly, for instance, or irregularly. Therefore, he could question the jurisdiction of the court over his person, but instead, he did not question the jurisdiction of the court, despite the defective service of court process. Did the court acquire jurisdiction over the person of the defendant? Yes, because jurisdiction over the person can be acquired by waiver, consent, or lack of objection by the defendant. MRR Company versus Attorney Gen. This is unlike the jurisdiction over subject matter, wherein the case could be dismissed upon filing in the wrong court. The Supreme Court said that when you remain silent despite the defects, your silence has cured the defect, meaning the jurisdiction over your person was acquired by waiver or consent or lack of objection. Question: distinguish jurisdiction over the subject matter from jurisdiction over the person of the defendant. Lack of jurisdiction over the person of the defendant may be cured by waiver, consent, silence, or failure to object, whereas jurisdiction over the subject matter cannot be cured by failure to object or by silence, waiver, or consent. MRR Company versus Attorney Gen. Voluntary appearance as voluntary submission to court's jurisdiction. Voluntary appearance must be the kind that constitute voluntary submission to the court's jurisdiction. Voluntary submission to the court's jurisdiction cannot be inferred from the defendant's mere knowledge or existence of a case against him or her. In general, the form of appearance that would be construed as a voluntary submission to the court's jurisdiction is an appearance that seeks affirmative relief, except when the relief is for the purpose of objecting to the jurisdiction of the court over the person of the defendant. Certain actions which could be construed as voluntary appearance are: 1. When the defendant's counsel files the corresponding pleading thereon. 2. When the defendant files a motion for reconsideration of the judgment by default. 3. When the defendant files a petition to set aside the judgment of default. 4. When the defendant and plaintiff jointly submit a compromise agreement for the approval of the court. 5. When the defendant files an answer to the contempt charge. And 6. When the defendant files a motion for certiorari without questioning the court's jurisdiction over his person. Navarro versus CA. Objections to jurisdiction over the persons of the defendant. An objection to the jurisdiction over the person of the defendant may be raised as a ground for a motion to dismiss. Section 1, Letter A, Rule 16. If no motion to dismiss has been filed, the objection may be pleaded as an affirmative defense in the answer. Section 6, Rule 16. If a motion to dismiss has been filed, the objection to the lack of jurisdiction over the person of the defendant must be pleaded in the same motion where such ground is available at the time the motion is filed. Otherwise, it is deemed waived pursuant to the Omnibus Motion Rule. The defense of lack of jurisdiction over the person of the defendant is not one of those defenses which are not deemed waived if not raised in the motion to dismiss. Only lack of jurisdiction over the subject matter, litis pendentia, res judicata, and prescription are not waived. Section 1, Rule 9 in relation to Section 8, Rule 15. Effect of pleading additional defenses aside from lack of jurisdiction over the person of the defendant. Under the former procedure, if the defendant raises the objection of lack of jurisdiction over his person in a motion to dismiss, the motion must rely only on that particular ground. If the defendant appears in court, objects to its jurisdiction over his person, at the same time alleges other grounds, the appearance would be deemed a general appearance, which was in effect a voluntary submission to the jurisdiction of the court. Republic versus Kerr. The above rule was re-examined in La Naval Drug Corporation versus CA. The pronouncement in said case are now embodied in Section 20 of Rule 14, which provides the inclusion in a motion to dismiss of other grounds aside from lack of jurisdiction of the person of the defendant shall not be deemed a voluntary appearance. Res is the Latin word for thing, that is jurisdiction over the res. It is applied to an object, subject matter, not nature of the action. Status considered as the defendant in the action or as the object against which directly proceedings are taken. Black, 5th edition. Define jurisdiction over the res. Jurisdiction over the res is the power or authority of the court over the thing or property under litigation. It is the power to bind the thing. How is it acquired? It is acquired either by the a. seizure of the property under legal process whereby it is brought into actual or constructive custody of the court, or b. as a result of the institution of legal proceedings in which the power of the court is recognized and made effective. Macahilig versus Years of Grace, M. Magalit. Q. A files a case for recovery of ownership against B over a piece of land. What is the rest of the case? The piece of land is the rest of the case. What is the nature of the action? To recover ownership of real property or real action. However, rest may not be tangible. For example, X, as an illegitimate child, she wants to be acknowledged by her father. Thus, she filed a case against her father for compulsory recognition. What is the rest? The rest is the status of the child because it is the object of the litigation. So why is jurisdiction over the rest important? Sometimes it is a substitute for jurisdiction over the person. There are instances when the court cannot acquire jurisdiction over the defendant, like when he is abroad. But if the court acquires jurisdiction over the rest, the case may go on, even if the court cannot acquire jurisdiction over the person of the defendant. Jurisdiction over the rest becomes a substitute over the person. In the example of action for compulsory recognition, even if the defendant is a non-resident who is out of the country, the object of litigation is status here in the Philippines, then acquisition of jurisdiction over the rest confers jurisdiction to the court, even if the defendant is abroad. The rest here is the thing or object or status against which, or in relation to which, the judgment can be enforced. Acquisition of jurisdiction over the rest by actual seizure is exemplified by an attachment proceeding where the property is seized at the commencement of the action or at some subsequent stage in the action. It is also acquired through a legal provision which authorizes the court to exercise authority over property or subject matter such as suits involving a person's status or property located in the Philippines in actions in rem or quasi in rem. Banco Español Filipino versus Palanca, 37 Phil 921. In land registration cases or probate proceedings, jurisdiction is acquired by compliance with procedural requisites such as publication. In a petition for change of name, the title of the petition must be complete by including the name sought to be adopted. Otherwise, the court acquires no jurisdiction over the proceedings. Telmo versus Republic. Jurisdiction over the issues. Meaning of issue? An issue is a disputed point or question to which parties to an action have narrowed down their several allegations, and upon which they are desirous of obtaining a decision. How jurisdiction over the issues is conferred and determined. In order to determine whether or not a court has jurisdiction over the issue or issues of the case, one must examine the pleadings. Define jurisdiction over the issues. Jurisdiction over the issue is the authority to try and decide the issues raised in the pleadings of the parties. Reyes versus Diaz. What are pleadings? Rule 6, Section 1. Pleadings are the written allegation of the parties of their respective claims and defenses submitted to the court for trial and judgment. In a civil case, pleadings are written statement of the respective positions of the parties, namely, the claims for the plaintiff and defenses for the defendant. Example, X files a case for collection of sum of money against Y. The pleading that X will file will contain the written statements of his claim. He will narrate there, for instance, that Y borrowed money from him, promising to pay it on a day certain, but when it became due, no payment was made despite demands. So he suffered actual loss or damage aside from moral damage. By way of response, X will file his position in writing, stating his defenses like denying the loan, the promissory note is a forgery, or admitting the loan but claiming that it had already been paid, or the action as prescribed. This written statement of his position containing his defense or defenses is a pleading called an answer. In the answer, Y can also allege claims. If he has any against the plaintiff, like the case is merely intended to harass him, for which reason he suffered damages. This is called a counterclaim. Another pleading, and X can in turn file an answer to the counterclaim, where he will state his defenses as regards the claim contained in the counterclaim. Based on their allegations and counter-allegations, the court will know what issues are to be resolved. Question: so if X says that Y borrowed money and never paid him, while Y in answer states that he did borrow but already paid it, what issue is being presented to be resolved by the court? Well, the issue is whether the obligation is still existing or is it already extinguished by payment. So that is how the court will know what it will try in this case. See, let us suppose that after the trial, the court said in its decision that the obligation has been extinguished by condonation. Will that bind? No, because the parties did not raise condonation as the issue. So the court decided that issue over which it never acquired jurisdiction. In other words, the court should only rule on what the parties raised in their pleadings. That is what we call jurisdiction over the issue. Jurisdiction of the issue is therefore conferred and determined by the pleadings of the parties. Jurisdiction over the issues may also be determined and conferred by stipulation of the parties, as when in the pre-trial, the parties enter into a stipulation of facts and documents or enter into an agreement simplifying the issues of the case. Section 2, Rule 18. Jurisdiction over the issues may also be conferred by waiver or failure to object to the presentation of evidence on a matter not raised in the pleadings. Here, the parties try with their express or implied consent issues not raised by the pleadings. The issues tried shall be treated in all respects as if they had been raised in the pleadings. Section 5, Rule 10. So, jurisdiction over the subject matter distinguished from jurisdiction over the issues. Jurisdiction over the issues is conferred by the pleadings and by the express or stipulation or implied failure to object to evidence, consent of the parties because an issue not duly pleaded may be validly tried and decided by the court as long as there is no objection from the parties. Jurisdiction over the subject matter is conferred by law and cannot be subject to the agreement of the parties. The following are distinctions. 1. Jurisdiction of the subject matter is the power to hear and try a particular case, while jurisdiction over the issues is the power of the court to resolve legal questions involved in the case. 2. Jurisdiction over the subject matter is acquired upon filing of the complaint, while jurisdiction over the issues of the case is acquired upon filing of the answer which joins the issues involved in the case. When an issue arises, even if not raised in the pleadings, although it is a rule that jurisdiction over the issue is to be determined by the pleadings of the parties, an issue may arise in a case without it being raised in the pleadings. This happens when the parties try an issue with their consent, under Section 5, Rule 10 of the Rules of Court. When issues not raised by the pleadings are tried with the express or the implied consent of the parties, they shall be treated in all respects as if they had been raised in the pleadings. Thus, if evidence on a claim for salary differential is not objected to, the labor arbiter correctly considered the evidence even if the claim is not mentioned in the complaint. Cindy and Lindsay Garment versus NLRC. Take note that jurisdiction over the issues in civil cases is acquired after defendant has filed an answer. In criminal cases, jurisdiction over the issues is acquired when the accused enters a plea of not guilty or pleads guilty but seeks to prove a mitigating circumstance. For a decision to be effective, the court must acquire the jurisdiction over the subject matter, the person, the resin case, the defendant is not around, and the last is jurisdiction over the issue. Jurisdiction over the subject matter, the Supreme Court. The highest court of the land is the Supreme Court. It was not affected by the judiciary, BP 129, which reorganized the judiciary in 1983. Being a constitutional court, its jurisdiction is found in the fundamental law itself. The Supreme Court is both an original and appellate court. Composition. It is composed of the Chief Justice and 14 associate justices. The Constitution ordains that the President appoints the members of the Supreme Court and judges of lower courts from a list of at least 3 nominees prepared by the JBC for every vacancy and requires the President to issue appointments for lower courts within 90 days from submission of the list, Article 8, Section 9, and to fill the vacancy of the Supreme Court within 90 days from its occurrence, Article 8, Section 4, Number 1. All such appointments need no confirmation, Section 9. Divisions in bank. The Supreme Court sits either in bank or in division of 3, 5, or 7 members. At present, it has 3 divisions of 5 members each. A decision or resolution of a division, when concurred in by a majority of its members who actually took part in the deliberations on the issues in a case and voted thereon, and in no case without the concurrence of at least 3 of such members, is a decision or resolution of the Supreme Court. Section 4, Number 3, Article 8 of the Constitution. The court en banc is not an appellate court to which decisions or resolutions of the division may be appealed. No doctrine or principle of law laid down by the court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. Section 4, Number 3. How a case before a division is referred to the court en banc. At any time after a division takes cognizance of a case, and before a judgment or resolution therein rendered becomes final and executory, the division may refer the case in consulta to the court en banc, which, after consideration of the reasons of the division for such referral, may return the case to the division or accept the case for decision or resolution. Cases assigned to a division including motions for reconsideration, which in the opinion of at least 3 members merit the attention of the court en banc, and are accepted by the majority vote of the actual members of the court en banc, may be considered as an en banc cases. A resolution of the division denying a party's motion for referral to the court en banc of any division shall be final and not appealable to the court en banc. When a decision or resolution is referred by a division to the court en banc, the latter may, in the absence of sufficiently important reasons, decline to take cognizance of the same, in which case the decision or resolution shall be returned to the referring division. Circular Number 2-89, effective March 1, 1989. En banc cases. In a resolution dated February 23, 1984, the following are considered en banc cases. A. Cases in which the constitutionality or validity of any treaty, executive agreement, law, ordinance, or executive order or regulation is in question. B. Criminal cases in which the decision imposes the death penalty. C. Cases raising novel questions of law. D. Cases affecting ambassadors, public ministers, and consuls. E. Cases where doctrine or principle laid down by the court en banc or in division may be modified or reversed. F. Cases assigned to a division including motions for reconsideration, which, in the opinion of the least three members, merit the attention of the court en banc and are acceptable to a majority vote of the actual membership of the court en banc. G. All other cases as the court en banc, by a majority of its actual membership, may deem as sufficient importance to merit its attention. H. Cases where the penalty to be imposed is the dismissal of a judge, officer, or employee of the Supreme Court, disbarment of a lawyer, or suspension of any of them for a period of more than 1 year, or a fine of 10,000 or both. I. Cases involving decisions, resolutions, or orders of the Sandiganbayan, COMELEC, COA, or military tribunals. J. Habeas corpus against government or military officials. Principal functions of the Supreme Court. A. Adjudication, judicial power. B. Administration or disciplinary power. C. Rulemaking power. Original jurisdiction of the Supreme Court. Article 8, Section 5, Paragraph 1 of the 1987 Constitution enumerates the original jurisdiction of the Supreme Court. Section 5. The Supreme Court shall have the following powers: exercise original jurisdiction over cases affecting ambassadors, other public ministers, and consuls, over petitions for certiorari, prohibition, mandamus, quo warranto, and habeas corpus. Note that the foregoing provision does not define the original jurisdiction of the Supreme Court as exclusive. Hence, it can be concurrent or exclusive. When is it exclusive and when concurrent? Original exclusive. The original exclusive jurisdiction of the Supreme Court refers to petitions for the issuance of writs of certiorari, prohibition, and mandamus as defined in Rule 65 against the following: A. The C.A. Judiciary Act of 1948. B. The COMELEC Article 9, Section 7, 1987 Constitution. C. COA Article 9, Section 7. D. Sandiganbayan, PD 1606. E. Court of Tax Appeals, because it has now the same rank as the CA by virtue of RA 9282. Original concurrent with CA. Cases where its original jurisdiction is concurrent with the CA are petition for the issuance of writs of certiorari, prohibition, mandamus against the following: A. The CSC RA 7902. B. Central Board of Assessment Appeals PD 469, BP 129. NLRC St. Martin Funeral Homes versus NLRC. D. Quasi-judicial agencies BP 129 RA 7902, or the Ears of Hinog versus Melicor. E. Also issuance of writ of certiorari, prohibition, and mandamus against the RTC. B. Concurrent with the RTC are those actions affecting ambassadors and other public ministers and consuls, Section 21, Number 2 of BP 129, or Article 8, Section 5 of the 1987 Constitution. Concurrent with the CA and RTC are those involving habeas corpus, quo warranto, and writs of certiorari, prohibition, and mandamus against inferior courts and bodies, Section 9, Number 1, 21, Number 2 of BP 129, or Article 8, Section 5 of 1987 Constitution. For example, a petition for mandamus against the MTC of Cebu can be filed with the Supreme Court, CA, or RTC, although the policy of the Supreme Court is that it should be filed with the RTC based on the hierarchy of the courts. Vergara versus Suelto. How about concurrent with CA, Sandiganbayan, and RTC? These are petitions for issuance of writ of amparo and petitions for habeas data, where the action involves public data or government office. And finally, with the advent of the new law, RA 8249, there is now a concurrence between the Supreme Court and the Sandiganbayan insofar as petition for certiorari, prohibition, mandamus, habeas corpus, injunction, and other ancillary writs in aid of the Sandigan Bayan's appellate jurisdiction, like only in connection with a case appealed to the Sandigan Bayan. This concurrent jurisdiction is subject to the doctrine of hierarchy of courts, Liga ng mga Barangay National versus Atienza, or Lacson Hermanias versus Ears of Ignacio. Appellate jurisdiction of the Supreme Court. The appellate jurisdiction is found in Section 5, Paragraph 2, Article 8, 1987 Constitution. Review, revise, reverse, modify, or affirm on appeal, or certiorari, as the law or the rules of court may provide, final judgments and orders of lower court in a. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. Letter B. All cases involving the legality of any tax imposed, assessment, or toll, or any penalty imposed in relation thereto. C. All cases in which the jurisdiction of any lower court is in issue. D. All criminal cases in which the penalty imposed is reclusion perpetua or higher. E. All cases in which an error or question of law is involved. If A, B, and C also involve questions of facts or mixed questions of facts and of law, the aggrieved party shall appeal to the Court of Appeals, and its final judgment may be appealed to the Supreme Court. Subparagraph 4, third paragraph, Section 17, Judiciary Act of RA 544. A. All cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. So if the RTC, which has the power, declares the law as unconstitutional, the same has to be appealed directly to the Supreme Court. It cannot pass through the CA because the CA has exclusive appellate jurisdiction regarding the matter. How about letter B? All cases involving the legality of any tax imposed, assessment, or toll, or any penalty imposed in relation thereto. This is related to the legality of tax cases, whether a tax or tax penalty is legal or not. However, whatever decision the lower court gives, it has to be appealed directly to the Supreme Court. And letter C, all cases in which the jurisdiction of any lower court is an issue. Example, the RTC or the MTC says it has jurisdiction or it has no jurisdiction over a case. The aggrieved party, if it wants to raise that issue, it must go to the Supreme Court. When the issue is purely jurisdiction, the Supreme Court shall have exclusive appellate jurisdiction. Now, when the law says all cases in which the jurisdiction of any lower court is an issue, the cases involve 100% pure jurisdiction as an issue. There are no factual issues involved. If the issue of jurisdiction is mixed with a factual issue, the appeal should be in the CA without prejudice to the filing of the same with the Supreme Court later. So this is 100% issue of jurisdiction. No factual issue is involved. And letter D, all criminal cases in which the penalty imposed is reclusion perpetua or higher. This was discussed in criminal procedure. Letter E, all cases in which only an error or question of law is involved. Take note that only an error or question of law is involved. So if there is a mixed question of law and a question of fact, appeal must be filed with the CA. You only go to the Supreme Court if the appeal is 100% legal. That applies to both criminal and civil cases. Questions of law and questions of fact. This is a question of law when the doubt or difference arises as to what the law is on a certain set of facts. There is a question of fact when the doubt or difference arises as to the truth or falsehood of the alleged facts. Spouses Santos versus CA. Example, where the question is whether or not the debtor has paid the debt, the issue is one of fact. Where the question is whether or not the manner of payment is of the type which produces the legal effect of extinguishing the obligation, the issue becomes one of law. Also, when under the set of facts, the issue is whether or not the law on double sales applies, there is a question of law. When the issue involves a review of the evidence, it involves a question of fact because evidence, as defined, is the means sanctioned by the rules as ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 1, Rule 128. In an action for declaration of nullity of marriage, the basis is psychological incapacity. The RTC or family court dismissed the case, finding that there was no psychological incapacity. If the plaintiff wants to appeal from that judgment, can she appeal directly to the Supreme Court? Is it a question of fact or law? No, the appeal should be to the CA. The issue raised is a question of fact because there is need to review the evidence to resolve it. Suppose the court nullified the marriage on ground of impotence and the defendant wants to appeal because he wants to raise the issue whether or not impotence is a ground for declaration of nullity of marriage. This would be a question of law because there is no need for review of the evidence to resolve it. So appeal is to the Supreme Court.